It's the success of the court that matters. And the success of the court at the Supreme Court level is getting those decisions right and getting good decisions that litigants and trial judges can use as they deal going forward. Now, one of my concerns as well is Justice Alexander is the only justice on the Supreme Court now who has ever been a Superior Court judge. And he's slated to retire next year, and then that kind of experience won't be there. And I think that's really important because Superior Court is where the trials happen. That's where you see real people, real litigants, and so on. And half the jurisprudence of the Washington Supreme Court is criminal cases. And I'm the only one here that's been a Superior Court judge. I've had an active criminal practice when private practice, and as a Superior Court judge, I do criminal cases plenty, in addition to the civil work we do. One of my concerns with Mr. Wiggins is he hasn't been near a criminal case in 15 years. And before that, his experience with it was limited.
So with that analogy, then, if you were a senator, U.S. senator, you would not vote for Elena Kagan, is that correct?
Well, based on her experience?
Yes. I mean, the way that you're explaining now that she doesn't have the bench experience and she's getting ready to be nominated for a Supreme Court justice position.
Well, I am concerned with an approach to legal problems that is purely abstract, which doesn't deal with what real human beings have to deal with real practical problems, not just of the people involved, but also having to carry out those things in the courtroom. Some of the decisions seem to be fairly impractical, and that can be disconcerting.
Can you give us an example?
Well, aren't we drifting a little bit here, folks? You asked one question, and it's,
Sorry.
the justice hasn't had a chance to hear it.
I'll step.
Well, there's 9 people on the state Supreme Court, and I think there's 9 people for a reason, and that is the Founding Fathers, although there was only 5 then, but the legislature has added to the number over the years, believed that there was strength in diversity on the state Supreme Court, that 9 different viewpoints is better than 8. If we wanted unanimity, if we wanted consensus, we could reduce the size of the court to 1, and then we'd always have unanimity, we'd always have consensus. But that's not what I think is behind this. It's a matter of, and it's not a matter of compromise. You don't compromise principles. You don't compromise the law. You try to ferret out the right result. You might disagree, but the whole system contemplates that there's going to be disagreements about appropriate legal principles, and that this is how we resolve it by majority vote on the court. When I was in private practice, I had a lot of appeals. Some of them I won, some of them I lost, but if there was a dissenting opinion, I always knew that the court considered both sides of the issue. They had to, they were forced to by the colleague on the bench who was stating a different point of view. And I can tell you as a matter of experience, it strengthens all of the opinions on the court because they have to deal somehow with the objections. And so we go through many drafts of opinions on the state Supreme Court when they're not unanimous. And I think that gives the lawyers cause to believe that we've given our full consideration. Remember taking a hike with Justice from the Oregon Supreme Court. We used to get together every summer. And we were at Glacier National Park. And I said, well, how often are you unanimous down in Oregon? He said, well, we think with one mind in Oregon about 95% of the time. And he said, how about Washington? I said, well, you know, in Washington we all think for ourselves. It's about 50% of the time. So I think that's a strength of the court. When Justice Chambers got on the court, he was talking about building consensus, and I hear the same sentiments reflected here. But he got over that in about 3 months and realized that these legal principles are in principle, are important. They're worth debating. They're worth fighting about. And at the end of the day, if a trial court judge can count up to 5, he knows what the holding of the case is, and we'll move forward. Sometimes dissenting opinions become majority opinions. Brown versus Board of Education was foretold by the dissenting opinion in Plessy versus Ferguson. So, as Justice Frankfurter said, wisdom that comes late is better than wisdom that comes not at all.
And your competence
Let me ask you a question, John.
Well, no, let me finish. Let him answer my question initially. And your competency score is what?
Well, I think we do a lot better if there are more Richard Sanders on the court, but I would probably go along with Brian, maybe an 8.
My question goes to the opening statements by your 2 opponents. And specifically, Judge Wiggins has, on the material that he handed out to us here, at the top of it, integrity and impartiality. He uses judicial ethics twice in his brief one-sentence thing. Are you saying that he's unethical, lacks integrity? You've clearly said he's impartial. He is not impartial.
That's correct.
Are you saying the rest of what this seems to me to be implying?
I do think that Justice Sanders has crossed the line on ethics, and it's not based on my opinion. It's based on the fact that the Judicial Conduct Commission found him to have violated the canons of judicial conduct. He was admonished. He appealed that. It was upheld by a panel of judges. And that was because he went down to MacNeil Island and, well, just stepping back, sexually violent predators confined at MacNeil Island invited all of the members of the court to come down and talk to them. And 8 of the judges said, don't think we're going to do that because there are cases that are pending. And we don't think that we're going to go down and do field research. We think that evidence comes into court under oath and subject to cross-examination. In fact, Justice Alexander, who was then chief, was quoted in the current issue of Seattle Metropolitan Magazine as having told Justice Sanders, don't do it. Justice Sanders went. And he did, in fact, visit this confinement center for sexually violent predators, and he did, in fact, talk to them. He interviewed them. And although he may have said, gee, I can't talk to you about the cases, the finding of the Judicial Conduct Commission was that he did talk to them about an issue that was pending in cases at the time, the issue of volitional control. And so that's why he was admonished, and he was found to have violated the canon, failing to uphold the integrity of the judiciary, and creating an appearance of or failing to preserve the appearance of impartiality. So it's not just my opinion. I think there are other issues there, too. I talk in my materials about the Yusufian case, the opinion he wrote in a Public Records Act case a year and a half ago. And by the way, it was a very favorable opinion for me at the time. I had a Public Records Act case pending, which I was seeking public access to public records. We won that. But as it turned out, the opinion that Justice Sanders wrote, his own lawyer cited to the Court of Appeals in support of Justice Sanders' own personal lawsuit pending in the Court of Appeals. And when that came out, King County moved to recall the mandate and set the decision aside, and the Supreme Court was embarrassed and had to do that, and had to redecide the case without him. So it's not just my opinion, it's really the opinion of the Judicial Conduct Commission.
Well, from the very beginning of this campaign, Mr. Wiggins has conducted what I would call personal character assassination. It's no longer possible to have an honest disagreement about how a case would turn out. He really doesn't want to talk about the reasoning of cases. He goes back to statistics, and he talks about claiming that I'm unethical. Well, let's examine some of the things he just said. If you read that Seattle Met article, Justice Alexander does say that he was worried about me taking the tour, not because it was unethical to take the tour, but because I have enemies, people that are out to get me. And if you read the Seattle Met article, you'll see the emails that were exchanged amongst people that did not directly contact me and the pressure that was put on other justices not to go on that tour. The Judicial Conduct Commission, the gravamen of the charges against me before the Judicial Conduct Commission was that I had improper ex-parte contact with litigants. That was what the whole trial was about, but at the end of the 5 days, whatever it was, all 11 members of the Commission on Judicial Conduct agreed that I had no improper ex-parte contact with anybody. I had advised everybody that I talked to not to talk about anything about their case, their personal legal circumstances, and none of them did.
So, Justice Sanders, why did you go?
Why did I go? Yeah. You know, judges are encouraged to take institutional visits. We have continuing...
For what purpose? For what purpose?
To learn about the institutions that we send people to. We get continuing judicial education credits for this. I got a credit for going on this tour. I don't know, maybe some judges never go on prison tours. Other judges go on them all the time. The Bar Association conducts these tours sometimes.